out there, and we'll take them as we go. We also want this conversation to also get the needed attention it deserves. So there's a hashtag we want you to add to comments that you may put on social media. The hashtag is Red Monday 1 year on. So just so that we are all clear with that. So let me invite a representative from the National Association for Law Students, Prince Ganaku, to give us a welcome address. If Prince is available to give us the welcome address, if not, we can pick another person from the association to do that.
Yes, please, I am.
Okay, Prince.
Good afternoon, everybody. My name is Prince Ganaku. I am one of the conveners of the National Association of Law Students. And before Prof gives his lecture, there are a few opening remarks that I'd like to. Now, on the topic of the lecture, I'd like to ask a few questions. Is there a right to not be offended? Is there a right to win elections? Is there a right to be popular? Our Constitution certainly doesn't contemplate these rights. But even then, under Article 33(5), rights which are not expressly mentioned or identified by the Constitution are capable of protection, provided they are inherent in a democracy and intended to secure the freedom and dignity of man. So, do these rights exist? Are you to be summarily thrown in jail for offending a police officer? Does one deserve to be assaulted by security agencies because they exercise their right to protest? What about the rights accruing from your citizenship of a country? Are they tied to the holding of any card or the ability to speak a language? Can you be stripped of those rights by any authority? Does the Constitution in Article 12(2) indirectly give the intelligence agencies the mandate to do all things, and I mean all things necessary to protect our collective interest in peace and security? Or is the BNI or NIB still subject to Articles 14, 15, 18, and 19? What about a right to legal education? Does such a right exist? A year ago, my colleagues and I mean most notably Regina Amega, Nicholas Apuku, Ni Adokwe Kujo, Philemon La, Jonathan Alua, and myself, Prince Ganaku, set in motion a chain of events in response to what we believe to be an egregious injustice. We were and still are described sometimes as entitled failed students, NDC apparatchiks with an agenda, among other choice characterizations, which there isn't enough time to go into. We were, of course, criticized for the course we took, derided for bringing the legal profession into disrepute, as though we were, and I quote, nursing students. We were doused with water, shot at with rubber bullets, while we were seated on the ground in silent protest, and many of our number arrested. And all we wanted was a fair opportunity to be educated. But a year on, notwithstanding the apparent imperfection of our methods, the powers that be smiled on us and our position was vindicated. In the 2020-2021 academic year, an unprecedented 1,046 students will be admitted into the Ghana School of Law professional course, provided they can sail through the registration process unscathed. To those who successfully made it this year, our arguments have not changed. This is not the time to gloat. Broad reforms are still needed to perfect an imperfect system. Do not be lulled into a false sense of superiority over those who didn't. If there was ever a time for us to work together among ourselves, on the one hand, and with the authorities on the other to reach our shared goals, it is now. To those who worked fervently behind the scenes to ensure a more equitable system of legal education and training than we had last year, in spite of scathing criticism leveled by many within our ranks and by many in the media, we thank you, we appreciate you, and we are under no impression that we could have done this without you. Special thanks must go to the unmatched and peerless Professor Stephen Kwaku Asare, who has been with us every step of the way. I can tell you that there were days when we were demoralized and the mountain seemed entirely too steep to climb, but Prof was always there spurring us on. Thanks also to lawyer Clement Akapam, who wrote on this same subject, the journalist Benan Avle, lawyer Samson Ladi, Professor Maxwell Upokwajiman, and most of all, thank you to the chairperson of the General Legal Council for keeping his promises to us and effecting the change we all wanted to see. We maintain that there is still a lot more to be done, but in working together, the only way is forward. Thank you very much.
All right. Thank you very much, Prince. You've raised a lot of key questions, and these questions, we are hoping that Professor and our panel will be able to answer some of these questions or address them. So I think it's the right time for me to introduce our keynote person. But let me say that last year we're part of journalists that marched with you during that period when you hit the streets trying to push for legal reforms, and we witnessed the brutality, among others, that was meted out to you. And even though the numbers this year in terms of people who get into the law school is not as high as it should be, we think there's been an improvement, over 23% increase in the numbers we are seeing. But let me bring in Professor Stephen Kwaku Asare. Who is he? Professor Stephen Kwaku Asare is a D&D fellow in public law and justice at CDD Ghana. He's also a KPMG professor in accounting at the Fisher School of Accounting. Professor Asare is better known in Ghana as a public intellectual and scholar activist whose contributions and activism, including as plaintiff in a number of precedent-setting cases before the Supreme Court of Ghana, are helping to push the frontiers of governance and the rule of law, particularly in the area of constitutional law and practice. So please help me welcome our keynote speaker for today, Professor Stephen Kwaku Asare. Prof, you have the floor.
Thank you so much, Vivian. What a warm welcome and good afternoon. I know there may be people listening from outside Ghana, and to them it may be in the morning, so I say good morning to them. To the executive of the association, National Association of Law Students, thank you so much for giving me this honor to come and participate in this commemorative event. To fellow panelists, my good friend Kofi Abochi and Steve Matthew, thanks for accepting the invitation to come and sit here and talk with me and with the students and to the nation. To everyone who has taken the time to make up this morning and show up and listen and participate, I also say thank you very much. Now, my friends, it is, as I said, a distinct honor and privilege to be invited to present the maiden and commemorative association lecture. I understand my task this afternoon involves commemorating and lecturing, and I'll proceed on that understanding. It was exactly a year ago that the association organized a peaceful demonstration to press for reforms in legal education. Regrettably, this peaceful demonstration, the right to which is guaranteed by the Constitution, was met with needless police brutality, reminiscent of the events that culminated in the Christianburg Crossroad shooting and other peaceful demonstrations under the various military regimes of yesterday. So did we go or did we come? Under the colonial era, under the military regime, and now under constitutional regime, peaceful demonstrations are met with police brutality. I'm delighted to join you to commemorate this Red October Day to restate and renew our demands for comprehensive reforms in legal education, to make it accessible, affordable, available, and adaptable while maintaining quality and excellence. As I've said repeatedly, abandoning the current bifurcated approach that decouples the so-called academic and professional courses must be at the heart of any such reforms. Further, we must take seriously the lesson we learned in Economics Without Tears, that monopolies are characterized by high prices, absence of innovation, output restrictions, excess profits, and poor customer service. My good friends and fellow countrymen, competition in the provision of legal education will drive innovation, efficiency, quality, excellence, and above all, is a constitutional imperative. I'm told that the results of the 2020 entrance examination are in, and 1,045 LLB candidates have been invited to the school. Notice, I don't use the word pass because I don't even know what it means in this context. 1,045 over 2720 is significantly better than 128 over 1820, but significantly short of our goal to allow anyone with a law degree to be given the opportunity to study and take the qualifying certificate of examination. 1045 over 2720 still denies 1675 LLB holders a mere opportunity to take the examination, the qualifying certificate examination. In my opinion, this is not progress. This is a gimmick. 1045 over 2720 also proves that 128 1820 was strange and surprising. You can use different S's if you choose, but this being a public forum, I want to restrict myself to strange and surprising. Our job, my friends, is not done until we totally and utterly dismantle the monopoly in the provision of the professional course consistent with Article 25(2). At the same time, let me also confess that I feel enormous pressure as the maiden speaker of this maiden and commemorative lecture. After all, I do not want to go down in history as the one who irreversibly altered and irreparably harmed the association's effort to institute a worthwhile annual public lecture. This is especially so as this is a virtual lecture, and I have come to believe that if anything can go wrong, it will when I'm delivering a Zoom lecture. The theme you have chosen touches on the issue of access to justice and vindicating constitutional rights. I always enjoy conversations that seek to evaluate the progress that you are making in asserting and vindicating the rights that are generously guaranteed under the 1992 Constitution. Our ability to assert and vindicate our rights and freedoms is the foundation of realizing the blessings of liberty that we seek for ourselves and our posterity. Under the colonial days and the military regimes, there were no constitutional rights to talk about, let alone access to vindicate them. Thus, after the Christiansborg shooting in February 1948, our forefathers got into more good trouble by organizing the Accra riots. But even before that, Kwaku III had organized a boycott of all European imports in response to inflated prices. These grassroots demonstrations were enough to trigger an
Sorry, I'm having trouble hearing you.
These grassroots demonstrations were enough to trigger an irreversible march to independence. Our independence history has not fully reflected the role of Kwaku III, Sergeant Ajete, Corporal Tipo, Private Lamte, and several others, especially those from outside the Gold Coast colony. Similarly, the history of National Union of Ghanaian Students is replete with peaceful demonstrations marred by military brutality. Today, very few remember Ajay Berima, the Legon student who was killed by a stray bullet from a police warning shot to disperse demonstrating students. I myself was a participant at a NUCS conference a few years ago when workers from Obuasi were sent to disrupt our proceedings. There was nowhere to seek justice when we were attacked by these workers. Therefore, we showed those workers a little atiwa. I've had to trace this history to remind you that peaceful demonstrations are in our DNA. And those who mar peaceful demonstrations make little atiwa inevitable. Therefore, what you did last year was a continuation of a long tradition. On the flip side, the security forces too never seem to learn from history. In a sense then, what your team is exploring is whether the advent of the Constitution has brought with it better avenues for and outcomes from vindicating those rights. For if there is no avenue to vindicate those rights when they are under assault, then we have just been given paper rights. Likewise, if there's an avenue to vindicate those rights, but the people seized with the power to do so are unable, unwilling, or otherwise reluctant to do so, then those rights are just vanity. In either case, the rights and freedoms become a compendium of high-sounding suggestions. Little atiwa becomes inevitable, albeit this time needlessly. It is trite knowledge that the Constitution guarantees and endows us with numerous rights that it describes as inalienable, fundamental, and entrenched. It further commands that these rights and freedoms shall be respected and upheld by the executive, legislature, and judiciary, and all other organs of government and its agencies, and where applicable to them by all natural and legal persons, and shall be enforceable by the courts as provided for in the Constitution. That's Article 12.1. In effect, what Article 12.1 is saying is that it is everybody's business to respect and uphold these rights and freedoms, but the court is the ultimate enforcer of those rights. In that regard, vindicating our rights must be conceptualized as a process that involves public advocacy, grassroots organizing, peaceful demonstrations, lobbying, legislation, and litigation. This reflects the notion that upholding constitutional rights is everybody's business, and we cannot count on the courts to always do it for us. In fact, considering cases like Ri Akoto, Dumogan, Francis, Tommy Thompson, etc., we probably should go to the courts as a very last resort. When you take a holistic approach to vindicating our rights, the field looks like this. I describe it as a 5-3-1 formation. You need to convince or persuade family and friends using private advocacy. Then you need to mobilize, organize, use demonstration, working with students, working with alums, with chiefs, with pastors, with the media and the CSO. I talk about the media and the CSO, that's more of public advocacy. Then while you are doing this, simultaneously, you are lobbying members of the Council of State, the legislature, the executive. And if all of this doesn't work, then we go to the court to litigate. So if you look at my involvement in legal education reform, the part that most people see is perhaps the litigation and maybe a little bit of the grassroots mobilizing using social media and other media. But in fact, behind the scenes, I also try to lobby members of the Council of State, members of the legislature, members of the executive. In fact, I've gone as far as to the president's office to press this case. And so that is the way we should think about vindicating our rights. Frequently, when you put something on social media, there are those who will come and immediately say, go to court, go to court. This reflects a fundamental misunderstanding of Article 12.1, The field is expansive, and we should continue to use the 5-3-1 formation in order to seek justice and in order to vindicate our rights. Of course, the court, once it is invited, has the final word. Therefore, I'm going to focus on the court as the ultimate enforcers of our constitutional rights, while emphasizing that rights vindication must be placed in the larger context of political negotiations. Two quick examples are the amendment of the Constitution to allow for dual citizenship in 1996, where we lobbied the 1996 Parliament and former President Rawlings, and the repeal of the criminal law in 2001, both of which were procured by advocacy and lobbying, and then ultimately by legislation. Now, that is the commemoration aspect. Let us go to the public lecture aspect, I am going to talk about the Asare doctrine because it bothers me so much. I'm going to argue that the Asare doctrine severely undermines our ability to vindicate our constitutional rights in the court, quite apart from being flawed. To do so, first, I'll discuss the Constitution's triangle defense. Second, I'll touch on the right to equal educational opportunities, only because we are talking about education, but this topic could reflect other rights as well. Then I'll discuss two cases on the right to equal educational opportunities to illustrate how the triangle defense is supposed to work. The big part of the lecture is the Asare doctrine, and this is something that I really want to get rid of because I've seen it in textbooks, and I even saw it on the exam, the qualifying certificate of examination, the interpretation section. There was a question on it, and there's a mistake that has been repeated by the court and has found its way to the exams. So this presents me a perfect opportunity to debunk that myth once and for all. I will then conclude. Now let's talk about the triangle defense. The framers' scheme for protecting the rights and freedoms can be found in Article 3.4, 2, and 130. I call this scheme the triangle defense. Article 3.4 imposes a duty to defend the rights and freedom. Article 2.1 provides liberal standing to all persons who are thereby commissioned as private attorneys general to enforce the Constitution. And Article 30 grants jurisdiction to the Supreme Court by commanding it to open its doors to anyone when any of two conditions are met. This is the triangle defense. It's very, very important. It's the most important defense scheme in the Constitution. Let's discuss them briefly. Article 3.4 says all citizens of Ghana have the right and duty at all times to defend the Constitution and to do all in their power to restore the Constitution after it has been suspended, overthrown, or abrogated. You will then see that the article talks about active resistance to people trying to overthrow the Constitution and then to restore the Constitution if it is suspended or overthrown, but also passive defense of the Constitution from assault by government and state actors. I conceptualize the former as active defense and the latter, where we defend it from assault by government and state actors, as passive defense. See, for instance, the December 31 case for an expansion of this concept. Article 2.1, on the other hand, grants standing to a person, not just regular people like you and I, but even artificial persons. Any person who alleges that an enactment or any act or omission of any person is inconsistent or is in contravention of a provision of this Constitution may bring an action in the Supreme Court for a declaration to that effect. That is very, very, very key, because this type of liberal standing does not operate in most of the world. It operates only in Ghana and a few other countries. I argue that the standing provision is the most important article in the whole Constitution. Under it, any person is empowered to defend the Constitution. The innovation, in my mind, means the court's rules of procedures, important as they are, should facilitate the hearing of the person, not frustrate it. Should facilitate the enforcement of the Constitution, not defeat it. When there's a conflict between procedural law and the substantive constitutional claim being advanced by the person, the latter must prevail as the ultimate end of the triangle defense is to enforce the Constitution. Article 2.1 basically is epistolic. It opens the door to Kwame Ahin. Kwame Ahin, you know, is the mythical figure, how much do I have? So I'm always quiet. The Article 2.1 is saying even Kwame Ahin can go to the Supreme Court to defend the Constitution. It used to be in our days in school, when we see the Achimota girls coming, we all shout, boy, the girls are coming. Where is the English that we can muster to meet them? Well, Article 2.1 is saying, don't worry about your English. You can even write chi and go to the court and seek an enforcement of the Constitution. It is a duty. It is a duty. Now, the third wing of the triangle defense is the jurisdiction or the forum for resolving the constitutional disputes. The Constitution says that it is the Supreme Court, subject to Article 33, that has jurisdiction in all matters relating to the enforcement of the Constitution. So when you want to enforce the Constitution under Article 2.1, the place you can go is the Supreme Court. It's the Supreme Court, unless you are an Article 33 plaintiff. Article 130 provides 3 independent grounds of jurisdiction: enforce, interpret, and ultra vires. Please pay attention, because this will become very important when we talk about the Asare doctrine. There are 3 independent grounds of jurisdiction. Enforce. To enforce is to compel obedience. To interpret is to assign meaning. Ultra vires is to act in excess of power. Enforcement does not require interpretation. Enforcement does not require interpretation. Enforcement does not require interpretation. Sometimes it does, but you cannot make a rule that unless there's an interpretation question, there cannot be an enforcement jurisdiction. That is plainly wrong, and I'll tell you that that is the Asare doctrine. It has no basis in our law, and I hope I'm giving the time to talk about it. Article 130 is a conscious choice to reject parliamentary sovereignty as it existed under the Independence Constitution. It is also a conscious choice to fuse constitutional enforcement role with the traditional rules, the traditional appellate rules and other rules of the Supreme Court. Thus, in Ghana, there's no standalone constitutional court as in the continental Europe or South Africa. Our Supreme Court is not just an appellate court, but it's also a constitutional court. It's also a constitutional court. So here we go. Under the triangle defense, in my mind, the court's enforcement jurisdiction is original, it is exclusive, and it is epistolic. Epistolic means it's open to Kwame Ahin. Epistolic means it is open to Kwame Ahin. One can easily see that the triangle defense presents a risk of too many cases being sent to the court for enforcement. Empirically, this has not been the case from 1993 to 2020. If you look at the enforcement case that have gone to the Supreme Court, it's not actually a whole lot. Moreover, the framers themselves anticipated this problem and created an architecture to deal with it. They allow a panel of the court to be properly constituted by only 5 justices, and there's no limit on the number of justices. So currently we have about 18 justices. That means at any point in time, there are 3 panels that can be sitting on different cases. So the case that they will be swarmed with cases, or there will be a floodgate of cases going to them, is entirely fictional. It's entirely fictional. To sum up, The Supreme Court is a repository watchdog of the Constitution. See Ghana Bar Association versus Attorney General, the Aban case. The members of the court, because of their important role in enforcing the Constitution, are also made to make an oath, to subscribe an oath. And in doing so, they say, I will truly and faithfully perform the functions of my office without fear or favor, affection or ill will, and that I will at all times uphold, preserve, protect, and defend the Constitution and laws of the Republic of Ghana. So help me God. This is an oath that courts, people who subscribe to it, must always look at in the morning before they take their seats on the court. And when they take their seat on the court, they must truly do justice without fear, without favor, without affection, without ill will. Don't look at the people before you. Don't look at the plaintiff. Don't look at the defendant. Look at only the law. Look at only the facts. If you do that, you serve your country well. If you don't do that, you betray your country. Why the triangle defense? Well, if you look at our history, it is replete with coups, both successful and foiled. In consequence, we have been under extra constitutional rule during the years of 1966 to 69, 72 to 79, and 1982 to 1992. The Committee of Expert and Consultative Assembly sought to design an anti-coup constitution. Their answer was the triangle defense, which makes everyone a protector of the Constitution, and therefore everyone feels like a stakeholder, so that if the Constitution is assaulted, everyone will feel like, hey, it is my job to defend it. It's my job to defend it. And grants easy access to vindicate the rights and freedoms therein granted, as well as any of its provisions. And then I show you here a good illustration of how the triangle defense should work. This is the Acha court. This is the Acha court, the first court when we went to the Fourth Republic Constitution. One of the cases that they dealt with has now been famously characterized as the December 31 case. But look at the timeline of the December 31 case. On 19 December 1993, government announces that December 31 will be commemorated as a holiday. 2 days after, the plaintiff, MPP, filed a suit challenging the constitutionality. 2 days after, the court hears MPP's application for injunction and decide that they are not going to rule either way, because when they rule, they would undermine the substantive suit. Rather, they ask that all of them should file their writs, and then the court will hear their arguments on 29 December 1993. On 29 December 1993, the court heard the case and delivered their judgment. That is how the triangle defense is supposed to work. The courts, like the Acha court, they have to understand their role, and they have to understand when the Constitution is being pushed. Now, there's a case in the Supreme Court. I don't want to talk about it because it's at the Supreme Court. It is an Asare versus Attorney General case where we ask that the court gives an opinion on whether the public accountant, the public auditor, can be sent on an involuntary leave. We filed a brief in July. The court went on vacation for 2 months. That, in my mind, it's not acceptable under our Constitution. That, in my mind, undermines the triangle defense. That, in my mind, could not happen under the Acha court. Another illustration of the triangle defense, this is the Aqua court. This is the Aqua court. Luke Mensah of Sunyani versus Attorney General. It's a 2004 case. Here, the plaintiff filed the case without the verifying affidavits or even joining the proper parties. The writ and statement of case made it very difficult to know what the issues are. Nevertheless, the court saw a constitutional issue, opened its door, and reframe the question as, when do newly created constituencies come into being for election purposes? Here's what the court said. We are convinced that as the highest court of the land, charged with the constitutional authority to interpret and enforce the Constitution, and thereby promote rule of law in our society, we should, in fitting situations, rise up to the occasion and determine disputes likely to endanger our infant democracy. And we will do this if the subject matter falls within our jurisdiction and the procedural errors committed by the plaintiff are not so fundamental as to amount to a denial of our jurisdiction. Again, very, very good application of the triangle defense. The triangle defense has done its job. Why did the triangle defense work in those cases? In those cases, I would argue that the early years of the fourth constitution, 1993, 94, 95, and so on, could probably be characterized as the golden age of enforcement. The courts from Archer to Aqua seemed to prioritize enforcement. Maybe because we had just emerged from the coup years and the coup days were fresh on our minds. So we didn't want to take the constitution for granted. There was active involvement by the political parties. MPP was in court, NDC was in court. The Ghana Bar Association was involved. See, for instance, the Kunyanya case. There were several outstanding issues from the military days. And if you look at the University of Ghana Law Journal, there was active public debate and commentary by the legal academy. I am afraid to say a lot of these factors are disappearing. And that is also affecting the court's seriousness in enforcing the Constitution. Now, there were some leakages in the triangle defense. I call those the purposive years. The enforcement became characterized by delays or inefficiency. All of a sudden, something appeared in our Constitution called an objective purposive approach. And the objective purposive approach introduced a reasonable person. What will a reasonable person think this constitutional provision means? Well, when a judge says reasonable person, he's going to assume he is the reasonable person. And then he's going to substitute his view of the provision for whatever the framers meant. So that whole idea of objective purposive approach, I don't like it. There was this notion of nuclear meltdown. You go to the court to seek enforcement, as in the Francis case, then the court will tell you, well, if we ask the administrative bodies to provide regulations, it will amount to a nuclear meltdown, so they can go home and do whatever they want. There was excessive deference to the executive and administrative bodies. Chances are the executive will win 80% of cases brought against them, even if they are clearly wrong. A recent example of that is the Ayine case on when the special prosecutor should retire. That case has no basis in law. There has become less involvement by the Ghana Bar Association and the political parties. There are less debates and commentaries, and all the debates and commentaries have been replaced by who won and who lost. People seem to be interested in only who won or who lost. Well, that's not how you evaluate a court case. You have to look at the judgment and say that, well, this one, the court said this, but we completely disagree with them. We completely disagree with them. And make known your disagreement in the media, in the academy, because that is the accountability that the court needs in order to wake up and in order to better perform its functions. Now let's move away from all that and go to the right to equal educational opportunities. That's important because it's in Article 25 and we are all students. If you focus on the right to equal educational opportunities, it's important. It says all persons shall have the right to equal educational opportunities and facilities. So that is the right to equal educational opportunity. They can't deny you a right to the opportunity. Prince asked, do we have a right to law school? Well, no, you don't have a right, but you need equal opportunity. You need the right is the equal opportunity. You cannot be denied that equal opportunity, okay? Now, they talk about F-cube, which is the basic education shall be free, compulsory, and available. Then the progressive FASE, progressive FAHE. So it goes from basic to secondary to higher education. Educational opportunities should be available. Then there's Article 25(2), which says every person shall have the right at his own expense to establish and maintain a private school or schools at all levels and of such categories in accordance with such conditions as may be provided by law. This is an anti-monopoly provision. It says, look, the government alone cannot provide all the schools that we need because the government has limited resources. Therefore, the government should not stand in the way of any private participant or educational institution that wants to provide, for instance, professional legal education. That will be against Article 25(2) because you'll be denying some people, in this case, 1,665, you'll be denying them the right to an equal educational opportunity. Why? Why do they spend so much time on this right, which is neither political nor civic? It's not one of those political or civic rights. The framers intended the state to have a positive obligation to make education available, accessible, acceptable, and adaptable. This is because education empowers people towards personal development, to contribute to society as an independent and emancipated citizen, to have control over one's personal life, to control the government, and to move up the social ladder. Further, education itself is a key right as it unlocks the enjoyment of other rights. You have a right to work. If you are not educated, you can't unlock that right fully. You have a right to health. If you are not educated, you cannot unlock that right fully. The right to food, the right to political participation, the right of women to equal opportunity and full participation. All of those are fully realized when you are given an opportunity to attain your educational goals. Government is charged to respect, protect, and fulfill these opportunities. And I explain what respect, protect, and fulfill means in this regard. So let's go to attempts to enforce the right, to equal educational opportunities. I'm going to talk about two cases. The one is PPP, or Progressive People Party versus Attorney General, and the other is Asare versus Attorney General, judgment delivered on July 28, 2020. PPP versus Attorney General, this is a simple case that sought enforcement of the F-cube. F-cube basically means free, compulsory, universal, basic education. Plaintiff, PPP, went to court and they said, hey, the government is violating Article 25(1)(a), and the government has a duty to compel attendance to the school. What did the court say? According to the court, the plaintiff made no effort to demonstrate any ambiguity, absence of clarity, or imprecision in respect of the articles relied upon, which calls for interpretive or enforcement intervention. That is, relying on Osei-Boating or the Osei-Boating doctrine, the court declined jurisdiction because there's no issue of interpretation. They said ambiguity is a necessary precondition for the invocation of our interpretive and enforcement jurisdiction. When you read PPP versus Attorney General, it says, in a recent 6-3 decision in Osei-Boating versus NMC, then they go on and they say the requirement of an ambiguity or imprecision and so on and so forth. My friends, today I'm going to tell you that Osei-Boating is not a 6-3 case. Osei-Boating is not a 6-3 case. That 6-3 case is a misunderstanding of Osei-Boating by the court, not just by the court, but I'm afraid this has found its way to the textbooks, because when you read a good book, a very good book, Modern Approach to Law of Interpretation by my brother Sir Dennis Ajay at page 454, he repeats this myth. He goes on the issue of whether or not the Supreme Court has the power the majority 6-3 in the case of Osei Boating. The majority 6-3 in the case of Osei Boating. And then finally, this majority 6-3 has even found a way on the qualifying certificate of examination. So if you look at the interpretation, those of you who like PASCO, or in this case, Present Co, because it just happened, interpretation 2020, it goes on and on. In Osei Boating, a majority of the court held that interpretation is a precondition for enforcement. Why? Well, they say, well, because if you don't say that, then there'll be a floodgate and many cases will come to the Supreme Court. This has no basis in law or constitution or the Constitution or in logic or in English language or in social, any evaluative lens that you use to look at this. It's funny. It's funny. It is something that the court should immediately abandon. I'll call this Osei Boating doctrine and as undermining the triangle defense. Suffice it for now to make the following observation, that they say it's a 6-3 majority. They say they rely on ex parte accusa. They say it avoids opening the court to a floodgate of cases. I'm going to discuss the doctrine as it applies to only Article 25, the education opportunity right. But remember that it has been applied elsewhere, notably in Agbleze and others versus Attorney General. This is the region creation case. Bonfe versus Attorney General. This is the cathedral case. So this doctrine is not just applied in education cases. I'm just limiting myself to education cases. Now, here is, so we are done with the PPP versus AG. Let me throw in another quick case, the Musa Mustafa versus University of Ghana versus AG case. This is the my good friend Larry's case, when the University of Ghana had road tolls and then they wanted you to pay to get there. But Musa Mustafa went to court, and one of the things they argued was that the UG road toll breached the right to equal education opportunity. Again, the court threw them out. They did not decide the issue on the substantive merit because they said there is no ambiguity in Article 174.1 or 25.1, and because there is no ambiguity, then we cannot have an enforcement case. And then the third one, the last one, is the Asare versus Attorney General, General Legal Counsel. This one is interesting because not only does it repeat the Osei Boating doctrine, but it adds its own doctrine, which is also wrong. When you go to that case and you read that case, they say, we argue that, look, the government is violating the anti-monopoly article, Article 25.2. The court held that, well, Article 25.2 is very clear and admits of no ambiguity. Okay, that's fine, that's Osei Boating. Neither does the provision of the professional and post-law course by the General Legal Counsel and the Ghana School of Law amount to a monopoly since no evidence has been demonstrated by the plaintiff. How did they get to that? Well, they are relying on NDC versus Electoral Commission. NDC versus Electoral Commission. In NDC versus Electoral Commission, the court says where an act or omission of any person is challenged under Article 2 of the 1992 Constitution, such an act or omission must be shown to have taken place and must be shown that such act or omission falls foul of a specific provision of the Constitution, or at the very least, the spirit of an actual provision. You have to go back and understand Article 2.1. Article 2.1 has two wings. It has two wings. One, you go to the court and you say an enactment violates the Constitution. If you say an enactment violates the Constitution, you made your case. You don't need any evidence. The evidence is the enactment itself. Then there's a second wing. The second wing is an act or omission. NDC versus Electoral Commission was dealing with the second wing, an act or omission. In that case, NDC went to court and said they've heard that the district officers are all going to be made to go home. And the court said, where is your evidence? Where is your evidence? NDC was not alleging that an enactment violated the Constitution. So with global respect to the court, it erred fundamentally when it relied on NDC versus Electoral Commission, and when it asked the plaintiff to provide evidence, where the plaintiff had indicated that LI 2235 created a monopoly by requiring all students to go to the Ghana School of Law.
Okay, Prof, I would have to interrupt you a bit. Mr. Ernest, Kofi Abochi has to take leave of us now. So I would want him to make a few comments on some of the things you said and what we intend to discuss, and then you take leave of us, and then you continue with the lecture if you agree to that.
Sure, it's your forum. So
okay, so Mr. Abochi, please go ahead with your comments, and then you can take leave of us.
Can you hear me?
Yes, Mr. Abochi, we can hear you. Please go ahead.
As I indicated, I was actually going to leave at 2 o'clock. So he still had a little time. I mean, so I don't know whether you want me to do it now or I should wait a bit.
Okay, if you're going to leave at 2 o'clock, Mr. Abochi, Prof has about 15 minutes to wrap up.
Yeah, let me wrap up very quickly.
Yes.
So that should be okay.
Okay. So that works. All right. Thank you. Okay. Prof, please go ahead.
Thanks so much, Kofi. Now, as I said, NDC is easily distinguished from Asare because in Asare, the plaintiff brings its action under Article 2.1a, whereas NDC brings its action under Article 2.1b. This is a very important difference, and we expect the court not to make such simple mistakes. The evidence under Article 2.1a is the enactment itself. Not only does Article 2.1a provide a jurisdictional basis for such an allegation to be heard, but also numerous cases from the court support the same conclusion, and I cite here so many cases. The court also cite several cases. One of them was Bimpon Buta versus General Legal Counsel. But the reason the court in Bimpon Buta declined the jurisdiction was not because there was no evidence. Rather, they declined this jurisdiction because they said Bimpon Buta's action was an action for wrong dismissal, clouded as a constitutional court, and they asked him he could go to the High Court. Where can Asare go to enforce Article 25.2? Asare cannot go to the High Court. Asare cannot go anywhere. They also mentioned the Aban case. Again, the reason the Supreme Court declined jurisdiction in the Aban case had nothing to do with evidence. Rather, the court said the action itself was an action for the removal of the Supreme Court justice, and because of separation of powers, and because there is a specific way to remove a Supreme Court justice, i.e. Article 146, the plaintiff should use Article 146 if it so desired. All right. Now, again, I've distinguished Asare versus Attorney General sufficiently enough, and we can go on so that we will get to the end of the discussion. Okay. Now let me talk about the Osei-Boating doctrine very quickly. The Osei-Boating doctrine arose in the Osei-Mensah case, and that case is a very simple case. The issue is whether the National Media Commission was violating the Constitution by appointing one of its members to the position of the director of the Ghana Broadcasting Corporation without affording other Ghanaians the opportunity to apply. So the plaintiff sought enforcement of Article 168, 23, and 296. Article 168 says the commission shall appoint the chairman and other members of the governing bodies of the public corporation. Article 123 basically says administrative bodies shall act fairly and reasonably. And Article 296 basically says where one is seized with discretionary powers, those powers shall be exercised with some fairness, with some candor, without arbitrariness, without caprice, or without bias. In Osei-Boating, the National Media Commission, that's the defendants, they raised a preliminary legal objection on 3 grounds. One, they said the court had no jurisdiction because Article 23 is a human rights provision and it should be enforced in the High Court. They also said Article 168 is clear, precise, and unambiguous, and plaintiff has not demonstrated that it has been breached. And then third, they said the NMC's power to appoint members to the GBC does not partake of any adjudication of a quasi-judicial matter, and as such, it's not amenable to Article 296. So that's the objections. On ground 1, the court dismissed it because it says, since the human right sought to be enforced is not in relation to the plaintiff, then they can enforce it at the Supreme Court. So yeah, that's a very good, a good distinction there's a difference between a right being enforced, which is your personal right, and a right being enforced which does not belong to you, but that seeks to enforce the Constitution. On ground 3, again, this was dismissed because the court said the parties have competing interpretations of the meaning of the discretionary power in the context of Article 296 and whether it applies to the exercise of the NMC power. Ground 2 is the interesting one. In ground 2, the defendant alleged that Article 168 is clear, precise, and unambiguous, and plaintiff has not demonstrated that it has been breached. With respect to that, the court dismissed the ground, okay? The court dismissed the ground. So anything that we are going to talk about Osei is even an obiter dictum. The court basically dismissed the ground and said, but only because the function exercised by NMC must meet the standard of Article 296, which is infected with uncertainty and imported into 168 to make it fit for interpretation or enforcement. So that was the reason for dismissing ground 2. However, in an obiter dictum, the court said, with respect to Article 168 itself, it must be stressed that ambiguity or lack of clarity is as much a precondition for the exercise of the exclusive original enforcement jurisdiction as it is for the exclusive original interpretation jurisdiction. That highlighted quote is the Osei doctrine. This is what the court said. I mean, not, I would say the court. This is what Justice Dateba, writing for the majority, said. Now, this created a lot of tension on the court. Ground 1 is dismissed, ground 2 is dismissed, ground 3 is dismissed. Summary, the court has jurisdiction, the case was handled, the substantive merits were decided. Why has this then become a wahala that has pissed me off so much? Well, there are 5 problems. Let me go to the first problem. On ground 2, there is a main opinion, and then there is a dissenting opinion, or Atuguban's opinion, or Justice Atuguban's opinion. On ground 2, the main opinion has a dicta on interpretation being a precondition for enforcement. So court members could vote in one of 2 ways: for the conclusion that the court has jurisdiction without opining on the dicta. So somebody can say, well, I don't want to get into this dicta because it's not important, so I'm just going to opine on the conclusion that there's no jurisdiction. Or somebody can say, I want to vote for the conclusion, but I also want to opine on the dicta. And for those who want to vote for the conclusion and opine on the dicta, they can agree with the dicta or they can disagree with the dicta. If you don't understand this framework and you read that case, you make the same mistake that the court made, and that has found its way to the textbooks, and that has found its way to the exams, the interpretation exams. Let me count it for you. Justice Dateba wrote the main opinion, and he said, in his view, that interpretation is a precondition for enforcement. Why? Because we don't want a floodgate of cases to the court. Justice Ansan, he said, I had the privilege of reading the opinions of my learned brethren, Atuguba and Dateba, beforehand, and I agree with the opinion, reasons, and conclusions of Dateba. So that's fine. So he agrees with Dateba, not just on the conclusion, but also on the opinion itself and all the reasons. So that's 2 for that. That's 2 votes. That's 2 votes. Let's go to Justice Atuguba. He agrees with Justice Dateba's conclusion to overrule the jurisdiction-based preliminary objection. However, he wrote separately to disagree with Justice Dateba on his obiter that the court's enforcement jurisdiction does not arise unless an issue of interpretation arises. So that's 1 for the disagree with the obiter. 2, Justice Akufu, for the reasons stated by my esteemed brother Atuguba, I agree that the objection be overruled. So Akufu is with Atuguba on the obiter. Then Justice Owusu, I've had the opportunity to read the judgment of my respected brother, and I'm in full agreement with the conclusion arrived by him. I've also looked at the judgment of the respected president on the issue of interpretation and enforcement jurisdiction of the Supreme Court, and I seem to agree with the distinction made by him that the enforcement jurisdiction can be enforced without necessarily having to interpret. So that's 3. 2 for Dateba, 3 for Atuguba, but it was a court of 9 people. So where are the 4 people? Well, let's go to the 4 people. Justice Bafuboni, he basically said, I've had the benefit of reading beforehand the 2 main opinions read by my brother Atuguba and Dateba. I also agree that the preliminary legal objection should be overruled. Look at that. He also agrees that the preliminary legal objection should be overruled. He has not stated an opinion on the obiter dictum. You cannot count Bafuboni's vote with either Atuguba or Dateba because he's chosen not to engage in that squabble between Justice Atuguba and Justice Dateba. Justice Adinyira is the same. I also agree that the preliminary objection is without merit and is hereby overruled. Well, he's just stating the conclusion that the court has jurisdiction without taking sides on the fight between Atuguba and Dateba. Justice Badegbe, I've had the advantage of reading beforehand the draft of the opinions just delivered by my worthy brothers. And I also agree that the preliminary objection be overruled, just the preliminary objection. And then Justice Banfo, I had the opportunity of reading beforehand the well-reasoned opinion of my respected brothers, Atuguba and Dateba. I agree with their conclusions that the objection be overruled. I therefore have nothing useful to add. These 4 amigos don't take part in that squabble. Somehow, people, the PPP court, the people who write the textbooks, and the people who write the exams have added these 4 amigos to the Justice Dateba camp to get to the 6 that they are talking about. There's no 6. There's no 6.
Prof, you have 4 more minutes to go.
Pardon?
You have 4 more minutes.
Okay. Once I'm done with this point, I'm happy. That the preliminary objection be overruled 4, 9, against 0, abstain 0. That the court's enforcement jurisdiction does not arise unless an issue of interpretation arises. 4, 2, Dateba and answer. Against 3, Atuguba, Akuku, and Awusu. Abstain 4, Adinyira, Bafuboni, Badegbe, and Banfo. So that's how they miscounted good. The floodgate argument is a hostile attack on the triangle defense because it ignores the fact that there's no limit on the number of justices. I already mentioned that 5 justices can form a panel and so on. They also misapplied the ex parte accusa doctrine because in ex parte accusa that the minority, the actual minority relies on. When you read ex parte accusa himself, the judge himself basically says the crux of the matter is whether the plaintiff's action raises any issue of either interpretation or enforcement. So the ex parte accusa court understood the difference between interpretation and enforcement, and the court misapplied that ex parte accusa when they relied on that. Let me go to my conclusions because there's no time. Article 130 is the only avenue to defend the Constitution as mandated by Article 3. Because the Supreme Court jurisdiction is original and exclusive, anytime they deny jurisdiction, they basically stop the Constitution from working, and that is a big problem that must stop. Jurisdiction must be determined as a preliminary matter and must never come as a surprise to the parties, as happened in Asare, where a plaintiff demonstrates that there's a prima facie issue of enforcement or an enactment. The court has a duty to hear it on the merits. A decline of jurisdiction imposes extraordinary burdens on litigants as they have no other forum to seek redress of their claims, which then makes them lose interest in the Constitution, and then they undermine the triangle defense. In summary, let me say, you asked me to talk about assessing justice and vindicating our constitutional rights. The framers erected a triangle defense for that purpose. Citizens have fulfilled their duty of private attorney general in attempting to enforce Article 25 of the Constitution. The courts have rebuffed them on grounds that severely undermine the triangle defense. The court must seriously abandon any reliance on Osei Boatin. The court must step up or risk becoming irrelevant. Thank you for giving me audience in your chambers. I wish the association continued success and look forward to future lectures. Thank you very much.
Thank you very much, Prof. Very insightful thoughts you've given us. Let me bring in Mr. Ernest Kofi Abochi. He's the Dean of the University of Professional Studies, as well as Dr. Samuel Mantia. He's a law lecturer, University of Ghana School of Law, and pick the initial thoughts about some of the key things you've raised over this matter. If we can start with Mr. Ernest Abochi. Let me also say that we'll open the floor for questions in a bit. I'll in a bit give you the rules around doing that. But because Mr. Abochi would have to leave us in the next 20 minutes, I would want to bring him in quickly, as well as Dr. Samuel Mantia, and then we'll start the panel discussion. So Mr. Abochi and then Dr. Mantia, I'll take your initial thoughts around the issues raised by Professor Asare.
Okay. Thank you very much, moderator. And let me thank my senior colleague, Professor Asare, who has, in my opinion, gone beyond even the topic to educate all of us on a number of things. I'm therefore going to try not to repeat some of the things that he said, a chunk of which I agree with, but to state my own perspectives and try to be as short as I can because of time. So the question before us, or the theme before us, is accessing, or rather access to justice and vindicating constitutional rights in Ghana. So here are some of the perspectives that I have in light of what the keynote speaker has said. Now, in terms of accessing justice, there are a number of subsystemic obstacles that undermines anyone's efforts trying to access justice in Ghana, particularly constitutional justice. Over 13, 14 years ago, in a paper, I questioned the Supreme Court's tendency to impose costs on litigating parties. The Constitution itself has created a public interest litigation under Article 2, Clause 1, in fact, starting with Article 1, Clause 2, and then ending in Article 130. The Constitution has made this a public interest matter because the winner of constitutional litigation does not gain a private interest. It is the whole country that benefits. So for example, Professor Asare's work in fighting for constitutional rights, the outcome is for all of us. It's not for him. And so why do we socialize the benefits and privatize the risk? It doesn't make sense. I realized the Supreme Court has over the years actually moved away from that. But there still remains cost in litigating constitutional matters. So the cost represents an obstacle, a systemic obstacle. We have other structural obstacles. We have realpolitik obstacle. A realpolitik obstacle is, for example, that a person who goes to court on a highly politically contested matter is given a political coloration. And so if NDC is in power and you go to court against the government, and it's a highly contested matter, you are deemed to be NPP. And vice versa, if NPP is in power and it's a contested political matter, you are deemed to be NPP. So these are realpolitik obstacles. And Prof mentioned the fact that the academy is quiet. The academy may be quiet because the academy doesn't want to involve itself in politics. Now, it may not be a justifiable reason because in the end, academics must do what they must do. They must speak up, they must be critical, and they must defend the public in areas bordering on the academy. So it's not a justifiable reason, but it's one of the obstacles. It's one that's worthy of note. Now, standing has always been a problem, and it shouldn't be. The Indian Supreme Court, and for example, Prof, you mentioned all these worries about people coming before the court and questions of standing and other difficulties. Look, the Indian Supreme Court has sought to rectify some of these difficulties by adopting what they call, for example, the epistolary rule. Under the epistolary rule, you can just write a simple letter to the Supreme Court. So a petition, a simple letter. It doesn't have to be legal language. Anybody can write to the court on a complaint. The court will assume jurisdiction. There will be no technical issues of whether you should have come by way of an originating motion, whether you should have come by way of a writ, and whether your legal documents are set. Because India's demography is like that of Ghana's, largely illiterate. And in a country of largely illiterate population, where the index between lawyers and the lay public, the ratio is so high that it's very few people have access to lawyers. If you do not remove the barriers of legal access to the court, what simply means that you are basically denying people access to the court. Of course, I can understand that the court is trying to avoid the difficulty of a floodgate, but there are so many ways of dealing with that. And that ties in with what Prof mentioned, the issue of jurisdiction. The fact that the court should not worry so much about jurisdiction, must try to assume jurisdiction in all cases. Look, there is a sifting mechanism that already exists. It is up to the court to apply that, and it's up to lawyers to also advert their minds to that. That sifting mechanism is what is called the May-Kankan principle. Under the May-Kankan principle, the court checks and evaluates whether if a matter comes before an ordinary court, a court, a lower court, so to speak, and the court has to determine whether the matter should be stayed and brought before the Supreme Court. The court has a mechanism for determining whether a jurisdiction should be stayed. I think the Supreme Court can expand the May-Kankan principle and make it mandatory, for example, that if before a matter is brought to the Supreme Court, probably should have had a preliminary hearing before a lower court, similar to the indictment principle, if the court is so worried about the issue of jurisdiction. So the May-Kankan principle can come to the aid. The second point I mentioned is the issue of reorientation of philosophy. Your worry, Prof, has equally been my worry. You reviewed a few cases. There's no need to repeat all of them. The reality is this. I've been worried about the court's constriction in terms of philosophy. If you read the decisions of the court, it does seem that it has gradually become a bit mechanical. The philosophy of the court reflects the philosophy of the common law court, i.e., the philosophy of the Supreme Court, if you read it in some ways, reflects the philosophy of, say, the High Court or the Court of Appeal. And that shouldn't be. The Supreme Court is a policy court, like it or not. The Supreme Court is a political court, not in the sense of NDC or MPP, no, but in the sense of decisions that are taken by the Supreme Court, decisions that are taken by the ultimate appellate court of the land must reflect certain realities. And constitutional matters are quintessentially political in character, like it or not. So the Supreme Court has political complexities, it has policy complexities, and then it has legal complexities. If you put all this together, you can even add sociological complexities. One of my most respected constitutional scholars called Carl Sunstein. Carl Sunstein published an article in which he asked whether Supreme Court justices should be worried about the consequences, as they call it, the consequentialist approach, whether the court should be worried about the consequences or the outcome of its decisions. And some advocates say yes, others say no. But the reality is that the Supreme Court cannot be insulated. And it cannot pretend as if it is just a legalese, very technical chamber. It is a court that must be alive to realities. And indeed, it often is alive. In this respect, the philosophy of the court must reflect one of liberality. It must be liberal in many ways. The idea of being conservative, of course, it balances liberality with conservatism. You can't just be liberal and change everything at any given time. But it must reflect certain degree of liberality, expansive scope, for example, a certain degree of progressiveness as a country. And so it's important that at least we pay attention to some of these things in a discussion or conversation like this. And I cannot help but just bring them. The third point is the issue of conceptualizing constitutional rights. We're discussing constitutional rights, but what are constitutional rights? Now, I'll tell you this. The gap or the transition between the rights which are provided and the rights which are implemented is critical. Prof mentioned 31st December. 31st December is one of the spotlights, is one of the most notable cases decided by the court. Because it was in that case that the courts actually did not have division. If you look at it carefully, there were really no divisions of the courts. In terms of ideology, in terms of appointment, there were no divisions. There were a certain sense of unanimity. The notable dissenter in that case, and you mentioned Justice Archer, but the notable dissenter in that case, Justice Archer, who dissented among others, using the principle of the spirit of the Constitution and saying, in fact, Archer was consistent from the case of Salah. In Salah, Justice Archer said, the law doesn't have a spirit. In 31st December, Justice Archer maintained or reiterated his position in Salah and said the Constitution doesn't have spirit. In fact, he was virtually a loner in that respect. And not only was he a loner, but his decision even flew in the face of the reality. It even flew in the face of the Constitution itself. The Constitution itself mentions its spirit. Yet Justice Archer in that case says the Constitution cannot have a spirit. So his decision was actually counter-constitutional in that case, but we live like that. The reality of the matter is we have to conceptualize what the right is. Because we have so many things in the Constitution that are rights, but the implementation is not easy. And since you suffered at the hands of the police, I'm talking about the association of the group, we can bring in what your experience was when you demonstrated. The Constitution says everyone has the right to assembly. Everyone has the right to movement. Everyone has the right to, to protest, to agitate, all that comes under the right of expression, the right of expression and assembly. The Public Order Act does not require permission of the police before one embarks on a demonstration. But anytime you hear the police actually speaks of permission. They forget that the law and the Constitution doesn't require permission. What the law requires is notification. The police can then say they do not agree with your demonstration because they are not ready for you. They think you breach the peace, you occasion a breach of the peace. But if the police comes to that conclusion, it is incumbent on the police at that stage then to go to court and to seek an injunction. But what we have often seen is that the police implements that rule as if it's a rule requiring permission. And therefore your failure to secure permission implies that if you go on the frolic of your demonstration, they will meet you with force. This particular provision and the reality of its implementation reflects the tension between provision and implementation in terms of speaking of constitutional rights. What are they? In this respect, therefore, we see a dominance of the executive when it comes to the implementation of constitutional rights. What is the scope of executive authority? Now, if you put this and you combine it with the difficulties or the subsystemic obstacles or difficulties that you have, including cost of litigating constitutional matters, including the structural weaknesses, including the real politic dimensions of it, the problems inherent in constitutional implementation becomes even greater. In this respect, I draw attention to the fact that as we have in the Wilsonian principle, that the life of the law is not logic, but experience. We all have to be mindful, therefore, of the reality aspects of the law beyond the principle. I think a lot of these Prof tried to do in his presentation, that there are certain realities that may often not be in the text. Of course, one of his lamentations is that a certain reality, which is a problematic reality, i.e. in his counting of what the majority or the minority is, I do not express my own opinion on that. I leave it like that. I will not express my own opinion. But taking what Prof said, i.e. the fact that his counting doesn't lead to the division, 6-3, 6-2, whatever, the division, his counting doesn't result in that. It just reflects his lamentations or his musings, reflect some of these difficulties, i.e. the difficulty of the principle of the law and the reality of the law. And as is well known by every law student, the life of the law is not logic, but it's experience. And the experience manifests in the actual implementation, which sometimes can be reflected in the disjuncture between provision and implementation. Now, 31st December therefore reflects a constructionist view. And I think Prof was trying to, if I got that right, we're trying to praise, among others, someone like Archer. 31st December may be one of our best cases, but even 31st December has not been fully implemented. And that is one of the difficulties, again, we have of constitutional provisions and even the decisions of the courts. Even when the court gives a decision, the interpretation of the court's decision can be problematic. And so sometimes in recent times, parties maybe have to go back to the court and ask the court for further direction in terms of what its own opinion means. Because opinion, when rendered, must itself be interpreted as to what the court meant, as to what the outcome means, what the effect of the decision is. And parties can contest this. And even that, you have to go back to court. It can become problematic one after the other. And then that brings in the issue of whether enforcement and interpretation are one and the same thing, or whether they are different, and if they are different, whether one is required before the other. Again, Prof's presentation makes it clear that it doesn't appear as if we've made much progress in this area. But the Sentinel decision, which was led by Justice Dateba, is one that I think calls for reflection by all of us, and I can't stay out of the phrase. So I will say, My own opinion is that I'm a bit persuaded by Justice Dateba's decision in this respect, because I think that is more pragmatic. The question of enforcement without interpretation appears beautiful on paper, but in reality, any enforcement will of necessity entail interpretation, because you are enforcing something, and that something you are enforcing invariably requires your clarification. Otherwise, you're enforcing something you haven't clarified, and the enforcement itself will lack substance, and that may call for further direction. In fact, that may be part of the reason why you have parties coming back to court asking for direction. Because the court's enforcement must of necessity be built on principle. And that principle is what Justice Dateba spoke about in terms of the preliminary interpretation. So while it will be beautiful, look, if you take the epistolary principle and you put that together with the Mekankan principle, and you put that together with Article 2.1 and 1.2 and 130, and you put that all together with Prof's frustrations, the court can be nominated. And so if you add enforcement as a primary requirement to, if you add interpretation as a primary requirement to all cases of enforcement, the court can possibly feel the sense of inundation. That look, we can collapse under the weight of too much work. So I can understand and I can appreciate some of the difficulties that the court has in this respect. But realities are also one thing on the other end of the spectrum. And that's what I'm thinking, that maybe the court may seek an aid under the old Mekankan principle, expand the principle, and probably give a mandate to a lower court, say the high courts, that in certain cases involving constitutional interpretation, maybe parties must seek a preliminary direction from the court. And the court, applying the Mekankan principle, may decide whether the Supreme Court should hear this at all. And we all know other jurisdictions do this. The Americans have a similar arrangement like this. So not all cases make it to the Supreme Court. There are many sifting mechanisms, and a good number of them, the courts may look at them and say, look, we're not even assuming jurisdiction. But in a small country like ours, and to avoid situations in which the court doesn't even look at it at all, I think we may want to look at a preliminary situation, a preliminary mechanism like I've suggested. Because I promised time, and I can see it's nearly 2 o'clock. Let me just make my last statement. It's very difficult for lawyers to speak in a short manner. I'll do my best. One last statement, and then I'll go. Okay. The issue of equal opportunities, because that affects all of us. I mean, particularly my colleagues, my college students, because we're all students. Now, the simple truth of the matter is this, and I intended originally not to make any statement on this, because the vituperative, and I use the word, or the big word vituperative, because it's highly charged. The highly charged circumstances of this discussion makes it difficult to win or to appease anybody when you make statements on this. But as someone who's been dean for the better part of 6 to 7 years, I will be remiss if I don't say a word on this. The truth of the matter is simply this: the provision of equal opportunity, which was again so well articulated by Prof, is one that cannot be ignored. Everybody must have equal opportunity. Now, equal opportunity, again, if you give it a superficial interpretation, it's very easy to say, well, everyone has equal opportunity. They all wrote the same exam, didn't they? They all attended law faculties, didn't they? They all applied equally, and they were all considered equally. When they, if someone has failed, they all had the same equal opportunity, etc. It's easy to say that. But the reality of the matter is that equal opportunity goes beyond that. Equal opportunity requires what we call similar situations and similar circumstances. So parties must be similarly situated. Now, similarly situated means A's paper must be marked in the same circumstances and manner as B's paper. But if there's no mechanism of ascertaining whether indeed A's paper was marked just as B's paper, then you have a difficulty dealing with similar situations, and you have a difficulty dealing with equal opportunity. If there are lack of clarity issues, and there are suspicions and allegations of non-similar situations and non-equal opportunity, you have difficulties. And that's where Article 296 of the Constitution comes in again. In the absence of clarity, the exercise of discretionary power will be deemed capricious. I'll leave it here. Thank you.
All right, Mr. Ernest Abuchi, Dean of the University of Professional Studies, is unfortunate you have to leave us, but thank you very much for your comments around Prof's keynote speech. If Dr. Samuel Mantea is ready, we'll take his initial comments, then we'll start the panel discussion proper and put some of the questions on the legal education proper, right to the panel. So Doc, we're ready for your initial comments. So while we are waiting for Doc, Prof, I started by asking you some questions since we started with the Supreme Court as well. And on your most recent case, the one to do with the Article 2 case, Asare versus Attorney General 2020. And over there, the Supreme Court said that it lacked the jurisdiction in deciding whether or not the Ghana School of Law had monopolized professional legal education, for which reason it should be liberalized for the law faculties to get involved. You disagree with the court. Explain to us some of the points of disagreement you have over that ruling.
Well, you know, in that case, the court did not really address the substantive case. They just claimed we have not properly invoked their jurisdiction. So there's no substantive decision for us to evaluate. So what we can evaluate is whether the jurisdictional decision is correct. In their decision, they basically said we have not properly invoked the jurisdiction on two grounds. One, we haven't provided any evidence that the Ghana School of Law is a monopoly. And then two, the Article 25(2) itself, it is unambiguous and therefore it does not require any interpretation. And since it doesn't require any interpretation, we cannot call on them to enforce it using the Osei-Boateng doctrine. Those two grounds are both flawed in the sense that one, when it comes to evidence, providing evidence to support a position, that is only required when you are an Article 2, 1B plaintiff. You see, when you look at Article 2.1, there are two grounds for going to the court. You allege that there's an enactment, there's some law that violates the Constitution, or two, you allege that there's some act or omission done by somebody that is inconsistent with the Constitution. If you allege that an enactment violates the Constitution, the evidence is the enactment itself. You don't have to go beyond anything to provide any evidence. And if you allege that there is an act or omission, then you have to provide evidence. So the court relied on the NDC versus Electoral Commission case. But in the NDC versus Electoral Commission case, NDC did not allege that an enactment had violated the Constitution. NDC alleged that the Electoral Commission and, in fact, a minister was going to do certain things, lay off district officers and so on. But they did not provide any evidence of that. And the court said, well, there's no evidence. And the people that you are accusing have denied that they have done what you are saying they have done. So the court really had no evidence. So to rely on NDC's case, when we were an Article 2.1 plaintiff claiming that LI 2235 violates the Constitution, was per incuriam. It was a wrong approach. Then the second one is the Osei-Boateng doctrine, which has many problems. One is that even just English language, you know that enforcement and interpretation means the same thing. So for instance, the right to vote, it says, if you are 18, you are sane, and you are a Ghanaian, you can vote. Everybody understands that. The court is saying, if you are 18 and the Electoral Commission doesn't allow you to vote and you come to them for an enforcement, they won't be able to enforce it because the provision is unambiguous. Of course it's unambiguous, but the fact that it's unambiguous doesn't mean somebody is not following it. To enforce means somebody is following something that is very clear to the person, alleging that the person is not following it. So the Osei-Boateng doctrine is completely wrong. It has no basis. And I'm not the only one saying that. Justice Atuguba also says that. And many, many cases also say that. In fact, If you look at the Asare versus Attorney General 2017 case, Justice Badegbe basically says there's no law which requires that there be an interpretative issue before we can enforce the Constitution. Justice Badegbe says that in his opinion. So I was quite surprised when in 2022 and when in 2020, he was part of the court panel that said that ambiguity is a precondition for enforcement. That is the basic problem I have with the court. And in fact, the mistake in my mind is so fundamental that it should not be allowed to stand. Because if it's allowed to stand, it will affect future cases. So I'm left with no option but to go and review that. It is a mistake on the face of it.
So if you get a review, and I mean, if you do not get a review, and for LLB holders or law students who fail to get into the Ghana School of Law for the professional law course, what other remedies can they seek in dealing with that?
Well, it becomes difficult. That's why I said sometimes the field for vindicating our rights should be construed more broadly than litigation. The courts consistently let us down. People think that the court is the first place you should go. No, the court is the last place you should go, because most court members tend to be very conservative. They don't like change. They side with the executive and so on. So one of the things that they can do is to actually push the political players. Parliament can enact a law today, which basically says all universities that have law faculties can offer all the courses that you need in order to take the qualifying certificate of examination. They can do that. If you look at the Parent Act, Act 32, Act 32 commands General Legal Counsel to set up a school or other educational institutions. So even as far back as 1960, when only 10 people were interested in attending the Ghana School of Law, Dr. Nkrumah and co. had the foresight to know that the population would grow, and as the population grows, there will be the need for other schools to participate in the provision of legal education. What is the rationale for asking somebody who lives in Tamale to relocate to Accra just to take courses? I mean, let's face it, when you go to Ghana School of Law, you are taking courses, civil procedure, you are taking evidence, criminal procedure, interpretation. I sometimes sit here in my room in Florida and I teach courses in Netherlands and China. Why should everybody converge at one Ghana School of Law to take these courses? What is so special about their facilities? What is so special about their professors? Why can't University of Ghana teach these courses? Why can't University of Cape Coast teach these courses? That is the bigger question that I think we must press forward, that the notion that there should be only one place where everybody goes to study law is a wrong one, because it even encourages every lawyer to think the same way. Lawyers should be exposed to different people. So for instance, they take a class from Professor Abochi. They also take a class from me. You can see Professor Abochi and I hold some different views on the relationship between interpretation and enforcement. If we are forcing all of them to go to the Ghana School of Law, and all of them are being taught by judges who are writing these same opinions that we are criticizing, when are we going to change? And so two things. One, I'm going to review. And if I review and they follow the law, I must prevail. But if I don't prevail, two, students should put even more pressure on the politicians to come in on an emergency basis to amend the legislative instrument to allow everyone who has a law degree to go to school. People sometimes think that what I'm arguing for is that everyone who has a law degree should be made a lawyer. No, I'm just saying that everyone who has a law degree should be given an opportunity to take an exam that allows them to qualify or not qualify as a lawyer. This is what they do at the medical school. It used to be everybody who wanted to be a doctor will have to go to Kolebu. In our days, you go to campus and you see the school bus, the Kolebu bus will come and pick them and take them back and forth. But the country has grown and the doctors have understood that they need to open up the system So now more than one school, there's Kolebu, there's a medical school in Tech, and so on. There are more medical schools now than there used to be when I was going to school. The same thing with nurses. You take your courses, then you go and sit for a licensing exam. The same thing with accountants. In fact, people can sit in Ghana and even take the Institute of Chartered Accountant, England and Wales, because it's an exam to demonstrate your proficiency. Anybody at all who has a law degree should be given the opportunity to demonstrate their proficiency by being allowed to take an exam. And if they pass the exam, then you call them. I'm not sure why people think it is funny to stop young people from pursuing their dreams. It is not funny. You are really ruining real people. I mean, we sit here and talk, but as we are speaking, over 1,600 students who have spent tremendous financial resources to get the LLB, and all they are asking for is to study some additional courses so they can take the bar exam, and we say no. Why? Just because they are Ghanaians. If they go to Rwanda, they can do it. If they go to Gambia, they can do it. If they go to Nigeria, they can do it. If they go to Kenya, they can do it. If they go to UK, they can do it. Why should we punish people because they are Ghanaians? That is something that I don't really understand.
Okay. If Dr. Samuel Mantia has joined us, if he can quickly acknowledge that, and then we'll rope him into the panel. But whilst we are waiting for that response, if it will come, I want to say that we'll open the floor for questions. If you want to ask a question, you send it into the chat box in the Zoom app. We'll have 2 rounds of questions. And then the questions in this case will be directed to Professor, since Mr. Buchi is not with us, and Dr. Samuel Mantia is yet to speak or respond to us checking if it's there. But before I open the floor, I want to ask you this question, Professor. Now, the Ghana Legal Council, for example, one of the main reasons for not opening the legal education, they've said, is because of the attitude of some of the lawyers. Now, how do we reconcile intellectual performance with the attitudinal and the moral aspect of a lawyer?
Well, those are 2 different problems, right? Because one, you are telling me that lawyers, after they've passed and become lawyers, engage in misconduct. And your solution to that is to prevent people from becoming lawyers. That actually makes very little sense. If lawyers engage in misconduct, there's a process for disciplining them. That is one of the proper functions of the General Legal Council, to have a disciplinary committee where cases of misconduct can be referred to them for disciplinary actions. That should be decoupled from the process of training lawyers. The process of training lawyers should be left to universities. Every country in the world, the universities are the best equipped to educate people. They have the libraries, they have the other departments to create the interdisciplinary, collaborative environment that students need to excel. They have the research resources. If I were to send my own family members to school in Ghana to study law, the last place I want them to go is the Ghana School of Law, because I'm going to say to myself, well, that's not a university. I don't want you to just go and study law. I want you to go to a place where, even while studying law, you can take a class in game theory, or you can take a class in the sociology of professions, and so on, to get a broad-based understanding. Good lawyers are good lawyers because they have a broad-based understanding. Why should we send everybody to one school so that they can all think alike, or what? It's just something that baffles me, because the original solution was proposed by Lord Denning himself. Lord Denning, our own Lord Denning. He was then sent by the British to study legal systems in Ghana and legal education in Ghana. And he and another committee that Nkrumah formed, they proposed that everyone should go to university to get their legal education, and then they go to a school to do some finishing work, to study how to keep their accounts and so on. So the Ghana School of Law was not even originally set up to train in the pure meaning of the word. It was set up to give lawyers practical training. Today, the universities themselves can do that. Most, if not all, the universities have moot courts. Their moot courts are better than anything that they can have at Ghana School of Law. Second, one of the most difficult things that a lawyer can experience is to read cases without understanding civil procedure. But because we have artificially separated professional and academic education, the students have to wait to get an LLB before they go to Mokola to take civil procedure. That is the worst way that you can arrange a legal curriculum. It makes no sense. And that is affecting our universities, because what happens when you compare universities globally is they look at your curriculum, LLB curriculum of Legon, LLB curriculum of UCC, LLB curriculum of Mount Crest, and they compare it with other curriculum from all over the world. And they look at our curriculum and it doesn't have civil procedure, it doesn't have evidence, it doesn't have criminal procedure. And they would ask, what kind of LLB is this? So it's very important for people to take civil procedure early at the universities. Forget about the Ghana School of Law. If they want to have a Ghana School of Law, they should have it. But they should also give other universities, private institutions, the opportunity to provide their education and compete with the Ghana School of Law. If 80% of the students who go to places other than the Ghana School of Law are passing, and 20% of the people who go to the Ghana School of Law are passing, what will happen? Ghana School of Law will die. But under the current monopoly, sometimes they tell us, oh, only 10% of the students pass, and what can we do? We just complain and nothing happens. If 10% of the students are consistently passing an exam, or 90% of the students are consistently failing, then the Ghana School of Law is the problem. It has to be disintegrated. It has to be given competition. Other people should come in to make it easier for the students to pass. Good teachers make students pass. Good teachers make students enjoy law. If you have a lecture from a good lawyer, a good law professor, I'm telling you, enjoy it. You will know it. You will pass it.
Okay, let me start taking the questions that are coming from the students and other persons who have joined us. Emmanuel's question to you, Prof, is asking whether there's any particular provision in the LI that mandates only the Ghana School of Law to run the professional course. My understanding of what the court says is that the fact that there's an LI does not mean monopoly is at play. The defendants also seem to suggest that should a private person right to seek for accreditation to run the professional courses, it will not be denied. Is this okay? So that's his question.
Yeah, I mean everybody in Ghana knows that the Ghana School of Law is a monopoly. I mean, all the universities there, they can read LI 2235 and understand it. The reason why people take entrance exam is not because they want to go to Ghana School of Law. It's because they are required to take the entrance exam to enter the Ghana School of Law. Look, you cannot take the qualifying certificate of examination without going to take courses from the Ghana School of Law. Even those coming from outside, if you are a lawyer who has practiced outside and you come to Ghana and you want to practice in Ghana, you cannot do so unless you go to school at the Ghana School of Law and do a post-call course and then take the exam, the post-call exam, before you can practice. So the notion that LI 2235 doesn't create a monopoly is a laughable one. No, that should not be taken seriously. I mean, I'm surprised that people even entertain that when LI 2235 Regulation 1, Regulation 2, Regulation 8, Regulation 10, Regulation 28, Regulation 30 all say very clearly that in order to take the qualifying certificate of examination, you have to take these courses that are offered at the Ghana School of Law. And the court really does not even get into regulations. In my case, it basically says we have not provided evidence. And what is surprising is that they don't mention, if you read the case, they don't mention even any of the regulations that we cited. The regulations that we cited have completely disappeared from the court judgment. That is a funny thing. I would encourage anyone who reads that case to do so in tandem with the writ that we filed. Then you can understand what we said, and you can understand what the court is saying, and then you can judge whether indeed what the court is saying is accurate.
So he's saying that can private law faculties then pursue this, since the Supreme Court seems to suggest they are not aware of any monopoly?
No, because you see, if you decide to open a private school, you need to get students, but no students will take the risk unless they are guaranteed that when they come to your school, they can take the qualifying certificate of examination. The qualifying certificate of examination is only offered for students who go to Mapola or the satellite campus. So you studying on your own, going to another school, and so on. The question is, how do you register for the qualifying certificate of examination? That's why what I'm recommending is the General Legal Council should have a bar committee, and that bar committee basically is responsible for setting exams, something like the IEC, the Independent Examination Council. They administer the exam maybe once or twice a year. And anyone who is a lawyer, you can go anywhere to study. You can even study on your own. Anyone who has an LLB and demonstrate that he has certain courses can apply to take the exam. And then every year they meet somewhere at some big the stadium. They put chairs there, and then they give them the exam. The exams are graded, and those who pass are called to the bar.
Okay. Larry Mohammed, his question is, what do you think accounted for the skyrocketing admittance of students this year than the last year? Do you think advocacy and activism worked to shake the status quo, or just that the admitted students somehow overperformed previous failures?
Well, you know, last year when the results came and it was 128 over 1820, I argued that statistically and psychometrically, the results were implausible. There's something wrong with the results. And then this year, we have that big shift. For the results to shift one way, this dramatic way, that tells you there's something wrong with the reliability of the exam. There's not something wrong with the students, because one generation of students, one cohort of students are not necessarily all that better than the other. What is happening rather is that the exam itself is not reliable, and basically they are using the exam to achieve some goal. That's why when I talk about the exam, I never use the word pass, because I don't know what pass means. Somebody just arbitrarily says, this year we want 1,000 students, so they're going to count how many people where should we leave the threshold so that we can admit 1,000 students? They say, okay, 50, then they put it at 50. If they want 100 students, they'll put it at 70. So the scale just keeps moving around. And it doesn't matter. What used to happen when we were struggling for independence is when we go and then we tell the British that, hey, we want independence, and we demonstrate and so on. The following time, they'll come, the following year, they'll come and they say, okay, now from the Gold Coast, we are going to allow you to have 10 more members on the Legislative Council. And then some people would say no. Nkrumah would say, we are not happy with that. We want independence now. What we want is not improved results. We want the monopoly to end now, today, as we are speaking. Nothing will make me happy to wake up and the president or somebody says, okay, 1675 students. The Ghana School of Law doesn't want you to come there, but you can go and take classes at Legon. Legon just recruited 11 professors. What are the 11 professors going to do? They can teach these students. We can go to UCC. If you live in Tamale, don't come to Accra, study at UDS. All the 2,700 students will study. At the end of 1 year or 2 years or however long, give them an exam. And then let's see what happens. Let's compare the results of the people who went to the Ghana School of Law to the results of the people who did not go to Ghana School of Law. That's a natural experiment. That will help us know whether indeed going to the Ghana School of Law is worthwhile or not.
Okay, this one believes that under the circumstance, should it not be the case that we test this law by getting a private person to seek for accreditation to run the Mokola kind of system, so that where the private person is denied, then we can confirm the monopoly position?
You can do that, but again, understand that the law is very clear. When you read Article 2.1, and everybody should read Article 2.1, Article 2.1 says a person who alleges that an enactment has violated the Constitution, or an act or omission have violated the Constitution. If there's an enactment, a law, LI 2235, and you read the LI 2235, and the LI 2235 says everybody should go to the Ghana School of Law to take professional law course or postgrad, you don't need additional evidence. The evidence is the enactment itself. To do all these things is the reason why sometimes they cheat us in Ghana, because we know what the law says, but then we do other things to make people happy. We have to insist on the law being enforced. Otherwise, they would always create new difficulties for us. Remember, the triangle defense requires that we have a duty to defend the Constitution when it is assaulted. Here, I'm saying that LI 2235 assaults the Constitution. The court should give me a forum under the triangle defense theory to hear my case, to read the enactment, and so on. Now, let me also say that even the General Legal Counsel and the Attorney General, they admit that there's a monopoly. Their argument in court was that the professional courses are exempted from Article 25(2). So that's what they argue. They did not argue that there's no monopoly. The argument that there's no monopoly, to me, is not a very serious one. They argue that, look, yes, there's a monopoly, but being the law school being a professional school is not one that is contemplated under Article 25(2). So that's what basically their case is.
Okay. SB Damta says, why is the law grading not a pass or fail? While it is a professional exam, they have A, B plus, C, etc. Does this not rather reflect academic grading system?
Again, I want people to make a distinction between a professional exam, which this one is not, and an exam to admit people to some school. This one is like the SAT, okay, SAT or LSAT. It's an entrance exam. Now, the difficulty with this entrance exam is that, unlike other entrance exam, which allows you to choose multiple schools, this one says you can only choose one school. And if that school doesn't want you, then you are cooked. So if you take the SAT, you can choose 4 schools. And if Harvard may say, we only take people who have 1,000. University of Florida will say, well, we can take you if you have 700. And they train you. Similarly, if you are doing SHS, the exam for SHS, or the other one, BEC, if you are doing BEC, which is an entrance exam, the BEC will not say, well, you can only go to Wegehe, or you can only go to Augustine's. And if you can't go to Augustine's and Wegehe, then you have failed. No, you haven't failed. It's an entrance exam. You don't go to Wegehe, you should be able to go to Imprisu Secondary School or some other secondary school, Latte Secondary School, and so on. That is what we call educational opportunities. You cannot have an entrance exam that screens out everybody and dooms them. That's basically what we have.
Okay. I think we'll wrap up on the questions. We'll take one more if there is, but in the meantime, I want to invite Philemon La, one of the organizers, to wrap up this conversation and also tell us the next line of action for this activism. So whilst we are waiting for Mr. La, let me ask you this. This question is coming from Yao. He wants, he says, what does Professor think about a uniform course which will outline and then a grading system for all LLB faculties? I've noticed that various faculties have different grading schemes and course outlines. So you want, you're asking whether there should be a uniform course for grading, among others, for LLB faculties, because there appears to be a difference in all of them. Prof, what's your thoughts about that?
No, the schools should be allowed to be creative. Okay, we allow the schools to be creative, but we tell them someone coming out as a lawyer should have proficiency in the common law courses, constitutional law, contracts, torts, and so on and so forth. Then when they are done, they have their LLB, they are going to, if they want, take a licensing exam. The licensing exam is administered by a different body. And one of the problems we have is, like when you go to Mokola, you know, some of the courses that they offer and can fail you, they don't even have anything to do with law. They have a course in accounting, and you can be denied an opportunity to become a lawyer because, I mean, you can't pass an accounting class. I mean, an accounting class should be an enrichment class. It's good for a lawyer to take it, but to fail someone or deny someone the opportunity of becoming a lawyer because he can't pass accounting or legal practice management, that doesn't make a whole lot of sense. In my mind, the bar exam, the qualifying certificate exam, is not even testing the proper courses. The proper courses that should be tested are the common law courses. You go and do whatever, then you do a bar exam that tests you on constitutional law, contracts, torts, property, administrative law. Those common law courses should be the basis of being admitted to the profession, not whatever they are doing at that so-called Ghana School of Law.
Okay, this one says, this is Kwaku. He says, Professor, the argument has always been that there are not enough lecturers to handle large numbers. And we've had instances where judges have berated lawyers for poorly representing their clients by sheer procedural lapses. How can that be addressed in the context of your call for access?
Well, because let's understand what he's saying. He's saying that currently lawyers who are trained at the Ghana School of Law are berated by judges because they are not properly trained. The answer means, or the answer doesn't have to be get more people to the Ghana School of Law to be poorly trained or get less people to the Ghana School of Law to be poorly trained. The answer has to be open it up so that there's competition. Competition improves quality, it improves excellence, it leads to innovation. Because if there's competition and you don't pull your weight, you're gonna fail. Right now, the Ghana School of Law, no matter what it does, is going to be around to collect 15,000 a year from students. It's guaranteed that. So what is the incentive for them to actually do well? What is the incentive for them to want the student to do well? Me, as a teacher here, I understand that if I don't do well, doing well means if my students are not understanding my materials well, my job will be on the line. The students will go to other places. And that in itself provides me motivation to work harder for them. So if we want good lawyers who will not be berated by the judges, let's go away from this Ghana School of Law training and do other things. We've done Ghana School of Law enough. Let's try something else.
Okay, I have to take this one. It's very sad. This is from Pupa. She says, Professor, I am very sad. I've been crying since Monday. I missed it by just 1 mark. I had 49 and I didn't get in. I'm very sad. That's pretty sad. So, Philomen La, if you're ready, let's take your vote of thanks and wrap up this discussion.
Vic, let me say something very quickly about Kukwa, the lady who was.
Please go ahead.
Think about it. What's the difference between 50 and 49?
Yeah.
And because of 1 point, you are going to waste 1 year of her life. What society is this? That will waste a young girl's life because of some 1 mark. You don't want her to go to Ghana School of Law, allow her to go to Gimpa or Legon or Mount Crest.
Okay, pretty sad. Philomen, you have the floor. Can Philemon hear us? Okay, so Prof, I'll let you take your final words around this, the way forward, what we can do in just a minute or two, and then we'll close the session. Just your closing remarks on all that we've spoken about.
Vivian, sorry.
Yes.
Vivian, Philemon is not available. Ni Adukwe, Joe, one of the conveners is ready to.
That's fine. So, Ni Adukwe, Kujo, please go ahead with that.
Okay, so thank you very much for this opportunity. We are grateful for Prof's insightful presentation. We want to encourage those who are requesting for the slides to note that we'll be publishing the proceedings of this lecture and forward it to the relevant stakeholders. But more importantly, we think that the conversation has started. The National Association of Law Students is here to stay. We are looking forward to other further engagement that would ensure that the profession we all desire to join and the training process continues to have the necessary engagement. In the coming months, we look forward to welcoming the students who have joined the Ghana School of Law, as well as those who will be joining the various law faculties, and possibly have other engagements. Possibly we will make these announcements in a soon to be announced event where we would formally outdoor the National Association and the new leadership that will be taken over, because yes, as association and as law students, we believe in term limits, and as those at the Ghana School of Law would be completing their study, others too will join in, and those at the law faculties who are ending their study will also be ending their term of office. Other new faces will come in. So we encourage the rank of the association to look forward to these activities that we would have to ensure that we engage ourselves and the stakeholders. We thank everybody for participating. We look forward, more importantly, to rebroadcasting the entire proceedings. We apologize profusely for the technical difficulties we have had, which, should I say on a lighter note, made this Zoom meeting an entrance examination that had a rather a mass failure. We're told at a point that not a certain number could not join anymore, but we'll work on it. It has been available on Facebook, but we'll ensure the rest is equally available. Hopefully, with our broadcast partners, we would work on this and make sure it's available to a larger audience. We thank you so much.
Okay, thank you very much, Adokwe Kujo. And Prof, you've been phenomenal. Thank you so much, Professor Stephen Asare, for joining us for this Zoom meeting. And to all of you out there, thank you so much for joining us. As said by me, there'll be a rebroadcast of this presentation together with the questions and the responses from Prof. Earlier, we had Mr. Bochi joining us. He had to leave us at 2 o'clock to join another meeting. But thank you all for joining us. Goodbye from us.
Goodbye. Thanks so much.